Um, so I just want to wish a happy birthday to somebody very special. That's the Hebrew birthday. They know who they are. I'm not going to put their birthday publicly on the group, but to have your birthday on Rosh Chodesh is very special. So it's just
My,
indicative of who
yeah.
they are. And Kevin, take it away for the initial teaching.
Okay, so this just continue from yesterday. It's all interesting stuff. So let me just continue. Okay, so it's a negative commandment not to demand a borrower pay his debt when he knows he doesn't have the means to pay. And it says in Shmot, you shall not be to him as a collector. It is forbidden for the lender to pass by before the borrower when he knows that the other has not the means to pay, so that he should not put him to shame. Yet, just as the lender is forbidden to make demands, so is the borrower forbidden to suppress the money due to his fellow man, to tell him, go and come back, when he hasn't. This is a prohibition from the words of the latter parts of Scripture. Do not say to your fellow, go and come again, and tomorrow I will give. When you have it with you, this is in Mishlei, when you have it with you in Mishlei, it is likewise forbidden for the borrower to spend the borrowed money needlessly until he is unable to repay it. He is called a rasha. As Scripture says, the wicked man borrows and does not pay. This is in Tehillim. Okay, that's, I think, is pretty self-explanatory. Next thing, it is a negative commandment to have no part in dealings between a lender and a borrower at interest. It says in Shmot, neither shall you put interest upon him, which means that one should not be a guarantor or a witness between them, and the lender is also included in the scope of the prohibition, apart from the injunction not to lend at interest to a member of jury. Any intermediary between them who brings them together who helps them arrange the loan violates the injunction, you shall not put a stumbling block before the blind. Now, let me just have a look at that again. It says, one should not be a guarantor or a witness between them. Okay, I don't know what that means, but because you're not supposed to charge people interest. I don't know what means guarantor. Don't know what that means. Why it says that there should not be a guarantor or a witness between them. And the lender is also included in the scope of this. Okay, not to lend interest. I don't know why I didn't just say that. Okay, and let's just see if there's anything else related to that. Okay, the last one. It is a negative commandment to lend nothing to a member of jury at interest, be it money or something to eat or anything else. And this comes from Vayikra. The term neshech, interest, and marbit, usury, are one thing. The scripture divided it into two terms to make the lender the transgressor of two prohibitions. The lender also violates the prohibition, neither shall you put interest upon him, as well as the injunction, do not take interest or increase from him.
The Gemara attempts one last proof, eh? Come learn a proof from the following Beraisa. If an owner of a field left pe'ah on one side of his field, and poor people came and collected stalks from another side of the field, both this side and that side are pe'ah. So what is a pe'ah? It's the corner of a field that you must leave to the poor. And I remember Rav Simcha Steinhauer discusses it. It's in Vayikra, Leviticus chapter 19, verse 9, and in chapter 23, verse 22. So the owner actually leaves a bit of the unharvested crop for the poor people to take. And what happens then, it's quite interesting, is he's not allowed to make the statement, this is what I'm giving to you. Rav Simcha Steinhauer gave a beautiful Mussar shir about it and saying that the person can't feel like a big balabas, and because there's nothing worse for a poor person than for somebody to say, "This is what I'm giving to you." You need to be grateful to me, and I'm you beholden to me. he's not allowed to issue any sort of statement like that. He's meant to allow them to take it without this constant level of observation, because Hashem instructed him to do it. So since Hashem instructed him to do it, he can't come across as this big deal and say, well, I'm the guy. You get what I'm saying, which is an amazing lesson about how not to embarrass the poor. It's one of the things that Kevin has been teaching us the last couple of days. It's in fact so amazing that Kevin teaches Minish and Mime what we're about to learn in the Gemara about when you're lending money or you're giving something, to have the sensitivity towards that person that doesn't have, and the poor to have sensitivity towards those that are lending their money, to basically keep their word and have a timeless payback to whatever capacity they can. Um, so with this corner of the field, what happened is that he made a particular corner available. And what happened is people started taking from that corner, and then another corner people started taking. So he's got a problem here because he's not obligated to give two corners. They're taking from this corner and they're taking for that. Now, if you say that a person may enforce the law for himself, why does the Mishnah rule that both this side and that side are pair? What does it mean? Because the law states that only in Leviticus that only one side is pair. So if you say that the poor are coming from this side and they're coming from that side, how can it be that the Mishnah itself talks about this side and that side being pair? It seems to contradict the Chumash, which can't be.
Sorry,
So
what
what
does
it
pair
say-
mean? Sorry, I apologize. I just don't know what it means.
Pair. Pair is it means corner. It literally means the word
Corner. Like payot also like in here. Payot. The corner.
Exactly.
Ah, okay.
Payot
Yeah,
is
it's a corner.
actually the word in Hebrew, yes. Yeah. It's corner,
Thanks,
yeah.
sorry. Thank you. Sorry, carry on.
Exactly. So it's the corner of a field. So what it's saying here is it can't be that the Mishnah is contradicting the Chumash at all. So the only other implication is perhaps it means that when the poor acquire the other corner, that at that point you can't take it back for yourself. Does that make sense? That's what it seems to be implying. That it's ideally they're not allowed to take more than one corner, but if they do, then the Mishnah speaks of this corner as being paired this side and that side, meaning it would seem as though you have to relinquish it. So if you say that a person may enforce the law for himself, in other words, if we're holding like both Rav Nachman and Rav Yehuda, we're saying that this guy is going to experience a loss. Why would he experience a loss? Because if he's losing on two corners of the field when he's only entitled to give one corner of the field to the poor, he's losing more than his obligation that he has to.
Yeah.
And in that case, both Rav Yehuda and Rav Nachman would deem it okay that he would sit at the edge of one corner with some farm workers and prevent more people of the poor from going in that area. We're not saying to beat the poor. We're saying to actually say to them, law for himself, even when he would otherwise suffer a loss. Does that make sense? So that's what it's proposing, that this seems even more stringent than Rav Yehuda and Rav Nachman.
Obligated to one corner, not two. And
Correct.
you shouldn't be cruel. You should try not be. You should still try to be sensitive.
Okay.
If they go to the second
But
corner.
But that's exactly what we're saying, Kevin. You don't beat them at the corner.
You can go.
When they go there, you try and like bar them from it, but not beat them.
Yeah, of
So
course.
when we say stay them at a stick, we're not saying that you jack a six like in cricket. We're saying that we use it to prevent them, almost like a barrier, as opposed to nobody here is advocating beating the poor. Believe me. But the problem is, Gavin, listen, I don't have too many.
No. This is not a question. There's a great solution for this. It's not directly related, but all you got to do is just set up two corners. It's obviously easier for the guys to access it. Make them smaller, so the two corners are smaller. Together they make one corner type thing.
Half size
Obviously,
each.
there are guys coming from the north, there are guys coming from the south, and that's why they're going to different corners because it's too far to get to the other corner. I'm just saying it's a solution. It's not related directly to this, but that's how I would set it up, so you don't have the problem.
Listen, there might be specific things in the Chumash where it says this is the size of one corner, and if that's directly in the Chumash, we can't use our own interpretation. You'd have to use literally what the Chumash would entail.
Okay.
There might be a specific parameter. I think it's a great idea, but there might be a parameter.
Yeah. No, it's just
Okay.
an idea. It's more of a
Otherwise,
solution that I thought would help, but it's not relevant to
but
what these guys
but
are saying.
no, no, no. I'm saying clearly, if it was a solution, this Bryson never would have come up. Which
Yeah.
means that the Torah obviously dictates one corner of a certain size.
Okay.
All right.
Good point. Good
Otherwise,
point.
the Bryson never would have come up. I
Yeah.
agree with you. It's a great solution. All right, let's cover some ground. Now, the major reason why you would have a loss is because you can't wait for the court in this particular case. It's one of the strongest proofs. Why is it the strongest proof? In any other case that we've judged so far, you can take this matter to court. You can't do it in this case. How are you going to extract money from poor people that are coming to get grain? And who are you going to take to court? One person? How are you going to take down roll call of the names of 30, 40 people that are on your field at the same time? How would you be able to recover that money? So this is the strongest proof that we have so far. Does that make sense? Because in any other case, you could say you would sustain a loss, but you would prevent a loss, but you could recover that loss in court. Every case that we've dealt with now, you're dealing with one person versus another, and you could take that to court and perhaps get your money back, perhaps. Um, but the first case with the water in the cistern is difficult because your crops might die and your animals might die of thirst in the interim. And this is also one of the strongest proofs because you can't extract money from the poor. So therefore, we want to prevent the loss before it comes to court because the court won't make restitution because you can't get money from them. There's too many people and they're too poor. Okay. So in this particular case, you've got that same sort of problem as we had before, that you had a lot of people in the public domain when you created another alternative route. Who are you going to sue? The public. Who are you going to sue? So it's difficult. So what we're saying here is that it can't be talking about that you are entitled to give both corners of your field. Because the Mishnah would never contradict the Chumash ever. So we need to understand what this means. So what it's saying is, what is the meaning of the Mishnah's ruling this side and that side of both pair? It's actually talking about a different case. This Mishnah treats both sides as pair only to exempt them from Maisa. So let me give you an example. Just let me continue and cover a bit of ground. It will make total sense to you. So according to this interpretation, what it means is that your fields that you own, you have to pay Maisa money to. Okay? Maisa is generally you pay a tenth of your earnings towards. There's different sort of things you pay. There's Truma, there's money to the Leviim, there's Maisa, there's Tzedakah, there's different categories of also agricultural tax that you pay to both the poor and to society. But if you're already having your field, your corner of your field donated to the poor, you're not then having to pay Maisa money on top of that. It's like in South African law, if you've got an 18A tax certificate, you don't have to pay on money that you've given away. Does that make sense? It's not yours. It's not yours. You've given it away. So when it says this field of PR and that corner field of PR, it means it's exempt from MISA tax. It doesn't mean it's exempt that the poor are entitled to take from both. That's the interpretation. And therefore, the inference of that. So what it's saying is that the original section is not PR in the sense that it must be made available to the poor. It's merely to exempt it from MISA, which means two corners are not allowed to be given to the poor. And therefore, you are entitled to protect your property in order to prevent a loss. So this is proving that you can protect it. Okay, just incidentally, I want to explain to you what your taxes are. So, if one basically it goes through in the Gemara in a particular Beraisa, if you declare your vineyard ownerless, say for example you've got a vineyard and you declare it ownerless, and then you arouse early in the morning, and then you say, listen, I'm reacquiring that particular vineyard. You don't then have to pay Misa on that particular vineyard, because anything that's ownerless that you find and then you acquire it, you're not subject to pay Misa, because the verse in the Misa is given as an instruction once, okay, in the Chumash, which means if you did have it and then you relinquished or lost control of it and you have it again, you're not obligated to pay Misa on that. However, you are obligated to pay um, the other sort of damage, not damages, other sort of taxes. You've got peret, you've got olilos, you've got shichacha, and you've got pea. I'm going to explain it, but it's not subject to the law of Misa. So let me just explain what you've got here. So any crop that was ownerless for a while, even if it was reacquired by the previous owner himself, it's not subject to the laws of Misa, because the Torah does not repeat its commandment to give Misa in Chumash. Thus, we see that even this minimal form of ownerlessness suffices to exempt a crop from Misa. Consequently, in the preceding case, where someone designated a corner of his field as peah, which is a type of ownerlessness. Why is it ownerlessness? Is because you're leaving it to the poor, and then you reacquire it. In this case, it was ownerless because the poor took two corners. So therefore, if you take back the one corner which is owing to you, because the poor are only entitled to one corner, then you're not required to pay Ma'aser on it. This is both according to Rashi and Tosfot. Okay, so there is an opinion that says you can't turn around and say, right, this is my vineyard, and now it's ownerless, and in the morning I'm going to get up and declare it mine, because then everybody's going to get out of Misa. So some opinions say that that doesn't hold. Otherwise, everybody would manipulate the system. Okay. So Peret is a special tax for the poor, not for the, from you to the poor, that grapes that fell during the harvesting of a vineyard, you're not allowed to pick them up. Okay. Anything that fell while you were harvesting has to go to the poor. The poor can come there and pick up those grapes, or you can put it in a container and the poor can collect it, but they're not allowed to be sold. Olilos are underdeveloped clusters of grapes. Okay. They haven't totally ripened yet. And then you've got shichacha, which is one or two trees that were forgotten by the harvesters and left unpicked. So any of these issues are special allotments to the poor, apart from the pear, the corn of the field. Now, all of those are not subject to Misa. Okay. So that's all that you guys have got to bear in mind, because it's.
So just repeat that, please. What are not what things are subject to Misa?
Okay, things that you're giving away to the poor.
Okay. Yeah, sure.
To the poor, like peret, olilos, shechicha, and pear.
Okay.
Giving it to the poor, so you don't have to pay Misa on top of it. So all this Beraisa is trying to say is, listen, you can claim back a corner of the field, because you've given away one. You're not entitled to give away two. You can protect something to prevent a loss, because you'll never get the money back in court from the poor. But because the poor have almost acquired it, and they've derived some benefit before you were able to chase them off on that one corner, because they've got another corner available, you can take back that original corner. But now, whatever money you lost, you haven't lost, because now you're not entitled to pay Misa on that corner, on either corner. Does that make sense? So your losses are being recovered, just as a matter of interest. All right, so what I want to do is I want to do a summary of every case up to now in a couple of sentences, and this will tell you who we judge by. So Rav Nachman, bottom line, says whether you would prevent a loss or not, you can take the law into your own hands, providing you would win that case in court. Prevent a loss by taking action with expediency, whereas if you had to wait for a court process, you would be losing money all the time and bleeding financially. In other words, while you taking a few months to bring this to court, the person is actually depleting your assets. So in that case, you can take the law for yourself. And Rav Nachman obviously agrees. If he agrees in a case where there's no reason because you wouldn't sustain a loss immediately, of course he's going to agree with Rav Yehuda where you would sustain a loss by waiting for the court. Does that make sense?
Yeah.
So there's no issue in terms of the agreement there. What we're trying to prove with all these cases is if in fact Rav Nachman is right. It seems that the Gemara agrees with Rav Yehuda in all these cases. There are certain cases where the Gemara is even more stringent than Rav Yehuda, that says you can't take the law into your own hands. So how does this appear? The first thing it appears is that Rav Kahana objected to Rav Yehuda's view, and he said Rav Nachman's got a point, because if somebody has your article in their house, you can go there and you don't have to stealthily go like a thief. You can smash their teeth if they won't give you the object back and say, I'm taking back my object. Because if you scuttle in like a thief in the night, it's as if you apologizing and it might not even be yours. That's how it would be perceived, because why are you sneaking? So that would seem to prove that Rav Nachman is correct. Why? Because you're not losing out while it's in the person's house. You might as well trouble the court. It's not like he's consuming it. It's not like a bottle of wine or oil. It's an object that doesn't deteriorate with use. Does that make sense? So that proves Rav Nachman. But then it turns around and because this was a thing by Ben Bugbug. So then the issue was no, that the court has to, Rav Yanai says that the court has to get involved, and the term smash his teeth is referring to where the judges take action on behalf of the person that's been aggrieved and has had his object not returned to him. But the problem with that view is that it's used in the first person, not the third person, which means you can go and smash his teeth and tell him to give you your object back. The judges would say, please give him his object back, and would smash him in his teeth. So the wording doesn't imply, obviously, troubling judges. So this is not a proof either way. Okay, then we've got a second case in summary of an ox, where a attacking ox on top of your ox, and we were saying that this prove Rav Nachman because the ox is muad. If the ox is muad, you're not going to lose any money, Kevin. Why? Because you're going to get your full money back. So therefore, you're taking action when you wouldn't appear to have any sort of loss prevention because you're getting your money back. So therefore, it seems to support Rav Nachman. But it doesn't support Rav Nachman entirely because this could be a tam ox. Therefore, if it's a tam ox, you could stand to lose money by only getting half the damages back from the body of the attacking animal. Does that make sense? The side note is whether you're responsible for killing the animal on top or not. But that is actually just a side note. We must remember the context of this is trying to prove if Rav Nachman is correct. So it's not because it doesn't specify whether it's a tam or muad. So this could be just to prevent a loss, and maybe Rav Yehuda is correct, of which Rav Nachman agrees. But it doesn't seem to extend to the point where Rav Nachman could take matters into his own hands, because it's not necessarily talking about a muad ox. And in the fact, the Gemara goes even more stringent, that if you throw the other ox off on top, that even when you could sustain a loss, you're liable for killing that other ox. So it's even more tough than Rav Yehuda and Rav Nachman. Then it goes to the next case. I hope, guys, you don't mind this sort of summary, but if we go through this for a few minutes, I've made use of all these examples, and you know where we're going with this thread of argument.
Yeah.
So it says, come learn a proof. If one fills the courtyard of his fellow with barrels of wine or barrels of oil, the owner of the courtyard may break them in order to exit and enter. So we're saying here, but listen, it seems to prove Rav Nachman. Why? Because you're not sustaining any real loss. The guy's blocked your pathway, Kevin.
Mm-hmm.
The guy's blocked your pathway. So if you're not losing money and you're not troubling the court and you're smashing the barrels, that seems that Rav Nachman is correct, that you can take the law into your own hands, even if you wouldn't sustain a loss. Because how are you sustaining a loss? What are you actually losing here? So then the Gemara says it doesn't necessarily prove Rav Nachman is correct, because there is a loss. If you're not going to be able to get from your house to work, you're going to get fired. Okay? If you're not going to be able to get from your house to outside, you're not going to be able to buy food or do anything to survive. You're stuck in your house or go to your farm. Okay? So there
Or
we
find a
would
shidduch.
what?
You won't be able to find a shidduch either.
Yeah. So,
Okay,
but then
sorry about this.
then it says, well, what about a case where you coming home from work, and then at the end of the day, you're not really sustaining a loss by going back into your place. So why can you smash his barrels? Because what are you losing? You got your food, you went to the shops, you went to work, you're not going to get fired. So you're saying, yes, listen, you can't sleep outside because maybe they're wolves. You need to sleep in your place. But maybe, bottom line, the Gemara uses the example, is your property deed is in your house. And since your property deed is in your house, you need to take that property deed to the court to prove, when the other person sues you for smashing the barrels, that he is trespassing on your ground and that's your property. And you need to actually prove this, because otherwise you're going to lose hours of time stacking barrels not to smash it because you won't win in court. Does that make sense? So it can't be proved that you won't sustain a loss. Therefore, it's not a proof that Rav Nachman is correct that you can just smash it even if you wouldn't prevent a loss. Okay, let's go to the next one. Then we talk about a nitza. So we're saying with a nitza, you don't want him to do another term, okay, working for you, and you're actually forcing him out of your house. Now, what loss would you sustain? You wouldn't sustain the loss. You've got a free slave now. Not free. In other words, you have to pay for his accommodation and everything, but he's not really costing you a lot of money. It's like a free asset. So it seems like Rav Nachman is correct. If you can take the law into your own hands and throw him out, what is he costing you that there's this urgency to get him out? Why? He's worked for you for 7 years. He's never stolen anything. It's not like he's a thief. So what do you have to get him out in a hurry? Therefore, you're not preventing a loss in the interim. And since you're not preventing a loss by chasing him out, what's the urgency for chasing him out, even if you have to smack him a bit or kick him out? Because what's the urgency? In other words, if somebody was stealing from you, you have to get them out your house. Otherwise, he's going to cause you a financial loss by stealing your goods. Okay? So therefore, Rav Yehuda would say, you've got a right to get him out. But because the guy's been with you for 7 years, Kevin, it's unlikely that he's going to steal. So if you can force him out by even physically pushing him, and you're not losing money in the interim until you go to court, it would seem that Nachman is correct, that you can get him out of your own house, even if there's no urgency to prevent a loss. You see how it proves Rav Nachman so far.
Yeah.
Fine, but then we're saying it's not that simple. There are two arguments against this. Firstly, is that the guy now is bitter because you don't want him back in his house. Okay? In your house. Why is he bitter? Because he's got a Canaanite wife and he's got non-Jewish children and he loves them, and you preventing him from seeing his family. At this point, he's going to get punitive and want to actually do things that might damage you because he's emotionally hurt, and you preventing him from seeing his wife and children. And therefore, you can't be assured when the relationship goes sour that even if he's had a good relationship while he's been under your roof, why wouldn't he want to steal before? I'll give you a perfect example. His wife is there, his children are there, right? So then if he stole from you, even if he had that in his nature, why has he got it in his nature? Because that's how he landed up there to start with, by stealing. And that's why he didn't have the money to pay back. Therefore, he was indentured to your servitude. But now that his wife and children are in your home, he wouldn't want to be barred from seeing them. And therefore, he's on his best behavior for 7 years. Now you've chucked him out where he can't see his wife and children. Then maybe that thieving mentality will come back, especially if he's upset with you, and he might cause you a loss. and therefore there's an urgency to get him out the house. That's one example that supports Rav Yehuda, to prevent a loss. The other one is you preventing him from transgressing, because at the point that he's free, he's not allowed to be with his Canaanite wife. It's prohibited by halacha. Therefore, you're preventing him from having a loss by transgressing. So you can intervene in order to prevent somebody from doing an aveira. So this proves Rav Yehuda, but not Rav Nachman, that you can take the law into your own hands unless a loss is prevented. Okay, let's go to the next one quickly. So the next one is saying, listen, we're talking about a case where somebody stumbles over a pitcher, and in that case, it talks about that. I'm not going to go through the pitcher and the barrel, and if you smash the barrels, you're entitled not to claim for medical aid. Let's just go to the next case quickly, which is a wife. So a wife whose husband is being attacked in a bar fight by another guy, just very quickly, grabs the assailant's private area in order to render him incapacitated, so he will be in absolute agony and won't attack her husband. So we're saying that was she entitled to take the law into her own hands, according to Rav Nachman, to stop this sort of behavior. And the Gemara proves that no, she's not. If there was any other way that she could have rendered the assailant, the one attacking her husband, to be incapacitated, she is not allowed to choose that method unless there was no other option. Because even though intention wasn't to embarrass him, it still created embarrassment. So therefore she pays for the actual damage of agony, as well as for the humiliation aspect. However, if she had no other choice, she's seen as an agent of the court, and therefore has full permission to do that if there was no other option, which proves that her husband needed to be protected, and she would have maybe lost her husband or had her husband badly injured had she not taken this action for herself. So this proves Rav Yehuda. It doesn't prove Rav Nachman that you can just take the law into your own hands. Otherwise, she's not considered an agent of the court, and she is held liable for these payments. Okay, then the next case. And the next case is as follows. Is that you buy over a field, Kev, you buy over a field, and that you're sick of people walking in this field you bought over, and then you build another pathway for them because they've got a public walkway. You build another one, and then why can't you take back the original public walkway? Because at the end of the day, this is not causing you real damage. Why is it not causing you real damage? Because, okay, people are walking on the pathway by your field, but what does it cost you? So it seems to prove that Rav Nachman initially is correct, because no harm done. But it is costing you money. Why is it costing you money? Because you built this new one. So therefore, you're still not allowed to take back your old pathway. So therefore, it then proves again Rav Nachman, because even if it would prevent a loss, you're not allowed to take the law into your own hands. So now it's much more stringent than Rav Nachman and Rav Yehuda, because it's even saying if you would prevent a loss, because you've already spent money on this other walkway, and if they could use the old one, then why did you build a new one? This is even more stringent. Never mind, it doesn't prove Rav Nachman is correct. It even says Rav Yehuda in this case is not correct, because where you would prevent your loss, you can take action for yourself. And the Gemara says, no, you can't. So it's saying that it's even more stringent than Rav Yehuda, where you can't take action for yourself. But it's saying it's not against Rav Nachman or Rav Yehuda, because you never got permission to do it. You had this scheme in your head. You didn't check it was legal. You never had a town council meeting. You're now going to create a path which is inconvenient to other people, and you should have checked it out, and therefore it's your problem. And because it's your particular problem, then you can't expect to recover your losses by sitting and preventing people from doing the old walkway, because this is not against Rav Yehuda or Rav Nachman. You were stupid. How do you build a new road and spend money if you don't get permission from the public first that they're prepared to forego the old route? Especially if the new route might be inconvenient for some people or not as superior in terms of material. So that doesn't prove Rav Nachman either. Or right. Then and there's a proprietary act on the new field, so you can't take back the new route either. Why? Because the public now have accepted it as a new alternative. They've made a chazaka, an acquisition. So you can't take back the new path either. Then the last case is you're talking about a field of pear. And you say that if you can prevent, well, you can't take the law into your own hands. So if you can't take the law into your own hands, then this seems more stringent than Rav Yehuda and Rav Nachman. But in fact, you can take the law into your own hands. Why? Because if you took this case to court, you'd never get money back from the poor. You're not allowed to beat them, but you can have maybe bodyguards on the one corner of the pair if people were taking, the poor were taking from multiple corners when they're only entitled to one. And therefore you can protect that corner, which proves Rav Yehuda. It doesn't prove Rav Nachman that you can take action if you wouldn't prevent a loss. Because here you are getting a loss because the poor are taking from multiple corners instead of just one. So you're losing revenue on one of the corners. You only have to lose revenue on one corner, not on all your corners or multiple corners. So this proves Rav Yehuda, which Rav Nachman agrees, but it doesn't prove that you can take the law into your own hands if you wouldn't prevent a loss. So thus, Rav Nachman's cases that you can take the law into your own hands even if there would be no loss sustained is not proven from all these cases. That's the summary of where we're up to now.
Very good, Damon. Thank you.